Civil War, and the United States government is running out of money to fight it. President Abraham Lincoln signs a bill that most Americans today would find almost unrecognizable, not because it created the income tax we know now, but because of how small, how temporary, and how quietly it happened. A flat 3% tax on incomes over $800. No IRS. No April deadline burned into the national psyche. Just a wartime emergency measure that almost nobody expected to last. It didn't last, not that version anyway. It would be repealed within a decade, struck down by the Supreme Court decades later, rewritten by constitutional amendment, and transformed almost beyond recognition by 2 world wars. The federal income tax most Americans deal with today isn't really 160 years old. It's the survivor of at least 3 separate near-death experiences. This is the real story of how the income tax started with Lincoln, why it was declared unconstitutional, how a constitutional amendment brought it back for good, and what people, including plenty of well-meaning history channels, still get wrong about it. Part 1. Lincoln's War Tax. Before the Civil War, the federal government barely touched ordinary Americans' income at all. Washington ran almost entirely on tariffs, taxes on imported goods, and excise taxes on things like whiskey. There was no infrastructure for taxing wages or salaries, and no real appetite for building one. The Civil War changed that overnight. By the summer of 1861, after the shock of the Union defeat at Bull Run, it was obvious this conflict would be longer and vastly more expensive than anyone in Washington had planned for. Lincoln began quietly asking his cabinet, Attorney General Edward Bates, Navy Secretary Gideon Welles, and Treasury Secretary Salmon Chase, whether the federal government even had the constitutional authority to collect a tax like this, particularly given his worry that ports in the seceding South might soon be beyond federal reach entirely. Congress answered with the Revenue Act of 1861, a flat 3% tax on annual incomes above $800, a threshold high enough that it excluded the vast majority of the population, since only a small percentage of Americans earned that much in a year. The law was broadly written, defining taxable income as gain from literally any source, property, profession, trade, or employment. It sounded sweeping. In practice, it barely functioned. There was no real collection mechanism, and the Treasury Department made little effort to actually enforce it before it was overhauled. That overhaul came fast. In 1862, Lincoln signed a far more sophisticated version, a genuinely progressive income tax, with a 3% rate on incomes between $600 and $10,000 and 5% above that. Crucially, this law also created the Office of the Commissioner of Internal Revenue, the direct institutional ancestor of today's IRS, giving the federal government, for the first time, a real administrative apparatus to actually assess and collect income taxes nationwide. Rates climbed further in 1864 as the war dragged on, and by the war's end, the income tax was generating roughly a fifth of all federal revenue. Here's a detail most retellings skip entirely. This wasn't just about money. Some of the law's chief architects in Congress, like Senator William Pitt Fessenden and Representative Justin Morrill, argued explicitly that the tax burden should fall more heavily on those with the greatest ability to pay it. An early, deliberate articulation of tax progressivity as a matter of fairness, not just wartime necessity. Morrill also specifically wanted the federal government collecting this tax directly, rather than through the states, to reinforce the idea that citizens owed their support to the United States as a nation, not merely to their individual state governments. A pointed message in the middle of a war being fought over exactly that question. The tax survived one important legal test during this period. In Springer v. United States, the Supreme Court unanimously upheld the wartime income tax as constitutional. But once the war ended and the emergency passed, political support drained away almost as quickly as it had appeared. Rates were cut in 1867. By 1872, with the country deep into Reconstruction and the immediate crisis long over, Congress let the income tax expire entirely. For the next 20 years, the federal government went back to funding itself almost exclusively through tariffs and excise taxes on liquor, beer, wine, and tobacco, which together made up roughly 90% of federal revenue through the rest of the 19th century. Part 2 struck down. The income tax stayed dead for over 2 decades, until the Wilson-Gorman Tariff Act of 1894 revived it, imposing a flat 2% tax on incomes above $4,000, a threshold that, once again, meant the tax fell almost entirely on the wealthy. It didn't survive its return trip to the Supreme Court. A shareholder named Charles Pollock sued to block the Farmers Loan and Trust Company from paying the new tax on the company's income, and the case, Pollock v. Farmers Loan and Trust Company, reached the Supreme Court in 1895. In a narrow, sharply divided decision, the court ruled that a tax on income derived from property, rent, interest, dividends, was, in effect, a direct tax. And the Constitution, in Article I, Section 9, required any direct tax to be apportioned among the states according to population, something this income tax plainly didn't do. The 1894 income tax was struck down, and the fledgling income tax division inside the Bureau of Internal Revenue was simply disbanded. The ruling was controversial even at the time. One dissenting justice, Henry Billings Brown, wrote that the majority's decision amounted to nothing less than a surrender of the taxing power to the moneyed class, a line that would be quoted for decades by advocates of reviving the tax. But for the moment, Pollock effectively closed the door on a national income tax, unless the Constitution itself changed. That's exactly what happened next, though it took almost 2 decades. In the aftermath of Pollock, Nebraska Senator Norris Brown proposed a constitutional amendment specifically designed to remove the apportionment requirement for income taxes, cutting the legal knot the court had tied. The proposal gained real momentum as the progressive era took hold in American politics, a period spanning the presidencies of Theodore Roosevelt and Woodrow Wilson, defined by growing public demand to rein in concentrated corporate and financial power and shift more of the tax burden onto wealth and high income rather than tariffs, which fell disproportionately on ordinary consumers through higher prices. Congress passed the proposed 16th Amendment in 1909, and it went to the states for ratification. It wasn't a sure thing. Amending the Constitution requires ratification by 3/4 of the states, and many observers doubted it would clear that bar. But on February 25, 1913, the requisite number of states ratified it, the first constitutional amendment in nearly 50 years. Its text was short and direct. The Congress shall have power to lay and collect taxes on incomes, from whatever source derived, without apportionment among the several states, and without regard to any census or enumeration. Congress moved almost immediately. Later in 1913, it passed the Revenue Act of 1913, establishing the modern federal income tax, with a top rate of just 7% and a bottom rate of 1%, applying to a relatively small slice of the population. 3 years later, in Brushaber v. Union Pacific Railroad Company, the Supreme Court upheld the new tax's constitutionality outright, closing the legal chapter that Pollock had opened 21 years earlier. Part 3. From a tax on the few to a tax on nearly everyone. The 1913 income tax looked almost nothing like the one Americans deal with today, and understanding how it transformed matters as much as understanding how it started. World War I drove the first major expansion, pushing top marginal rates dramatically higher to fund the war effort, before rates fell again in the 1920s. But the truly decisive transformation came with World War II. To fund a war effort on a scale the country had never attempted, Congress dramatically lowered the income thresholds at which the tax applied, turning what had been, for 3 decades, essentially a tax on the wealthy into a tax that reached deep into the middle class for the first time. At the same time, the government introduced automatic payroll withholding, deducting income tax directly from paychecks before workers ever saw the money, a system designed for wartime efficiency that has quietly remained the backbone of how most Americans pay income tax ever since. That's the arc worth holding onto. The federal income tax wasn't born as the broad, universal, paycheck-deducted system we know today. It was born as a narrow wartime emergency measure, killed off once the emergency passed, revived and constitutionally cemented as a tax squarely aimed at the wealthy, and only turned into a mass tax on ordinary workers by the demands of a Second World War 3 decades later. What historians actually get wrong. Myth 1. The 16th Amendment was never properly ratified, so the federal income tax is technically illegal. This is, by a wide margin, the most persistent income tax myth in America, and it has a very specific origin. A 1985 book called The Law That Never Was, which claimed to document that most states botched the ratification process through inconsistent capitalization, punctuation, or wording, and that Ohio in particular wasn't even legally a state at the time. Every one of these claims has been tested in federal court, repeatedly, for decades, and every court to consider them, without exception, has rejected them. Courts have found that minor variations in spelling or punctuation across different state legislatures' ratification documents don't invalidate ratification, since the substance of the amendment's text was consistent across every version. And the specific Ohio argument fails on its own terms. Congress formally confirmed by joint resolution that Ohio statehood was retroactively effective from 1803, decades before the 16th Amendment was even proposed. This theory has landed real people in real prison, including a well-known actor and a reality TV personality, for acting on it. It is not an open legal question. It is a thoroughly settled one. Myth 2. The income tax was always meant to hit ordinary working Americans, the way it does today. The opposite is closer to the truth, at least for the tax's first 3 decades. Both the Civil War income tax and the 1913 tax that followed the 16th Amendment were structured, quite deliberately, to fall almost exclusively on the wealthy. The 1861 and 1862 thresholds excluded the vast majority of the population, and the 1913 law's top rate of 7% applied to a genuinely small slice of high earners. The income tax as a mass, middle-class, payroll-withheld institution is a World War II invention, not a 1913 one. Conflating the two eras, treating the tax's original design and its later wartime expansion as the same thing, misses one of the most important turns in the whole story. Myth 3. The Supreme Court ruled income taxes unconstitutional in Pollock, full stop, meaning the government was operating illegally for 2 decades until 1913. This overstates what Pollock actually held. The court didn't rule that a federal income tax could never exist. It ruled that this particular tax, insofar as it touched income derived from property like rents, interest, and dividends, functioned as a direct tax and therefore had to be apportioned among the states by population, which the 1894 law failed to do. That's a narrower, more technical holding than income taxes are unconstitutional, and it's precisely why the fix Congress and the states pursued was equally narrow and technical. A constitutional amendment removing the apportionment requirement specifically for income taxes, rather than some broader relitigation of federal taxing power in general. Myth 4. This was purely a wartime necessity with no ideological dimension, a practical measure, not a political one. The record doesn't support treating this as apolitical. From the very first debates over the 1862 Act, its architects explicitly framed graduated rates as a matter of fairness, taxing people in proportion to their ability to pay, in Representative Morrill's words. And the 16th Amendment's path through Congress and the states in the early 1910s was inseparable from the broader progressive era political movement, which saw an income tax on wealth and high earners as a deliberate counterweight to a tariff system that critics, including dissenting Justice Brown in Pollock, argued protected concentrated wealth at ordinary consumers' expense. The income tax's origin is a story about war financing, yes,